Art. 1. This code shall take effect on January 1, 1932. Art. 2. Except as provided in the treaties and laws of preferential application, the provisions of this code shall be enforced not only within the Philippine archipelago including its atmosphere, its interior waters and maritime zone, but also outside of its jurisdiction, against those who 1. Should commit an offense while on a Philippine ship or airship. 2. Should forge or counterfeit any coin or currency note of the Philippine Islands or obligations and securities issued by the government of the Philippine Islands. 3. Should be liable for acts connected with the introduction into these islands of the obligations and securities mentioned in the preceding number. 4. While being public officers or employees, should commit an offense in the exercise of their functions. Or, some of these crimes are bribery, fraud against national treasury, malversation of public funds or property, and illegal use of public funds. E.g., a judge who accepts a bribe while in Japan. 5. Should commit any crimes against the national security and the law of nations, defined in Title I of Book 2 of this code. These crimes include treason, espionage, piracy, mutiny, and violation of neutrality. Rules as to crimes committed aboard foreign merchant vessels. French rule. Such crimes are not triable in the courts of that country, unless their commission affects the peace and security of the territory or the safety of the state is endangered. English rule. Such crimes are triable in that country, unless they merely affect things within the vessel or they refer to the internal management thereof. This is applicable in the Philippines, two situations where the foreign country may not apply its criminal law even if a crime was committed on board a vessel within its territorial waters, and these are 1. When the crime is committed in a war vessel of a foreign country, because war vessels are part of the sovereignty of the country to whose naval force they belong. 2. When the foreign country in whose territorial waters the crime was committed adopts the French rule, which applies only to merchant vessels, except when the crime committed affects the national security or public order of such foreign country. Requirements of an offense committed while on a Philippine ship or airship, registered with the Philippine Bureau of Customs. Ship must be in the high seas or the airship must be in international airspace. Under international law rule, a vessel which is not registered in accordance with the laws of any country is considered a pirate vessel, and piracy is a crime against humanity in general, such that wherever the pirates may go, they can be prosecuted. U.S. versus Bull. A crime which occurred on board of a foreign vessel, which began when the ship was in a foreign territory and continued when it entered into Philippine waters, is considered a continuing crime. Hence within the jurisdiction of the local courts. As a general rule, the revised penal code governs only when the crime committed pertains to the exercise of the public official's functions, those having to do with the discharge of their duties in a foreign country. The functions contemplated are those, which are, under the law, to be performed by the public officer in the foreign service of the Philippine government in a foreign country. Exception. The revised penal code governs if the crime was committed within the Philippine embassy or within the embassy grounds in a foreign country. This is because embassy grounds are considered an extension of sovereignty. Paragraph 5 of Article 2, use the phrase, as defined in Title I of Book 2 of this code. This is a very important part of the exception, because Title I of Book 2, Crimes Against National Security, does not include rebellion. Art. 3. Acts and omissions punishable by law are felonies. Acts, an overt or external act. Omission, failure to perform a duty required by law. Example of an omission: failure to render assistance to anyone who is in danger of dying or is in an uninhabited place or is wounded. Abandonment. Felonies, acts and omissions punishable by the revised penal code. Crime, acts and omissions punishable by any law. What requisites must concur before a felony may be committed? There must be 1. An act or omission, 2. Punishable by the revised penal code, and 3. The act is performed or the omission incurred by means of dolo or culpa. How felonies are committed? By means of deceit, dolo. There is deceit when the act is performed with deliberate intent. Requisites: freedom, intelligence, intent. Examples: murder, treason, and robbery. Criminal intent is not necessary in these cases. 1. When the crime is the product of culpa or negligence, reckless imprudence, lack of foresight or lack of skill. 2. when the crime is a prohibited act under a special law or what is called malum prohibitum. In criminal law, intent is categorized into two. 1. General criminal intent, and 2. Specific criminal intent. General criminal intent is presumed from the mere doing of a wrong act. This does not require proof. The burden is upon the wrongdoer to prove that he acted without such criminal intent. Specific criminal intent is not presumed because it is an ingredient or element of a crime, like intent to kill in the crimes of attempted or frustrated homicide, parricide, murder. The prosecution has the burden of proving the same. Distinction between intent and discernment. Intent is the determination to do a certain thing, an aim or purpose of the mind. It is the design to resolve or determination by which a person acts. On the other hand, discernment is the mental capacity to tell right from wrong. It relates to the moral significance that a person ascribes to his act and relates to the intelligence as an element of dolo, distinct from intent. Distinction between intent and motive. Intent is demonstrated by the use of a particular means to bring about a desired result. It is not a state of mind or a reason for committing a crime. On the other hand, motive implies motion. It is the moving power which impels one to do an act. When there is motive in the commission of a crime, it always comes before the intent. But a crime may be committed without motive. If the crime is intentional, it cannot be committed without intent. Intent is manifested by the instrument used by the offender. The specific criminal intent becomes material if the crime is to be distinguished from the attempted or frustrated stage. By means of fault, culpa, there is fault when the wrongful act results from imprudence, negligence, lack of foresight, or lack of skill. Imprudence, deficiency of action, e.g. A was driving a truck along a road. He hit B because it was raining, reckless imprudence. Negligence, deficiency of perception, failure to foresee impending danger, usually involves lack of foresight. C. Requisites: freedom, intelligence, imprudence, negligence, lack of skill or foresight, lack of intent. The concept of criminal negligence is the inexcusable lack of precaution on the part of the person performing or failing to perform an act. If the danger impending from that situation is clearly manifest, you have a case of reckless imprudence. But if the danger that would result from such imprudence is not clear, not manifest nor immediate, you have only a case of simple negligence. Mistake of fact is a misapprehension of fact on the part of the person who caused injury to another. He is not criminally liable. A. Requisites: that the act done would have been lawful had the facts been as the accused believed them to be. Intention of the accused is lawful. Mistake must be without fault of carelessness. Mistake of fact would be relevant only when the felony would have been intentional or through dolo, but not when the felony is a result of culpa. When the felony is a product of culpa, do not discuss mistake of fact. Art. 4. Criminal liability shall be incurred. 1. By any person committing a felony, although the wrongful act done be different from that which he intended. Article 4, Paragraph 1 presupposes that the act done is the proximate cause of the resulting felony. It must be the direct, natural, and logical consequence of the felonious act. Causes which produce a different result: mistaken identity of the victim, injuring one person who is mistaken for another. This is a complex crime under Art. 48, e.g., A intended to shoot B, but he instead shot C because he, A, mistook C for B in error in personae. The intended victim was not at the scene of the crime. It was the actual victim upon whom the blow was directed, but he was not really the intended victim. How does error in personae affect criminal liability of the offender? Error in personae is mitigating if the crime committed is different from that which was intended. If the crime committed is the same as that which was intended, error in personae does not affect the criminal liability of the offender. In mistake of identity, if the crime committed was the same as the crime intended, but on a different victim, error in persona does not affect the criminal liability of the offender. But if the crime committed was different from the crime intended, Article 49 will apply and the penalty for the lesser crime will be applied. In a way, mistaken identity is a mitigating circumstance where Article 49 applies. Where the crime intended is more serious than the crime committed, the error in persona is not a mitigating circumstance. Mistaken blow. Hitting somebody other than the target due to lack of skill or fortuitous instances. This is a complex crime under Art. 48, e.g., B and C were walking together. A wanted to shoot B, but he instead injured C in aberratio ictus. A person directed the blow at an intended victim, but because of poor aim, that blow landed on somebody else. In aberratio ictus, the intended victim as well as the actual victim are both at the scene of the crime. Aberratio ictus generally gives rise to a complex crime. This being so, the penalty for the more serious crime is imposed in the maximum period. Injurious result is greater than that intended, causing injury graver than intended or expected. This is a mitigating circumstance due to lack of intent to commit so grave a wrong under Art. 13, e.g., A wanted to injure B. However, B died. Prater intentionem is mitigating, particularly covered by paragraph 3 of Article 13. In order, however, that the situation may qualify as prater intentionem, there must be a notable disparity between the means employed and the resulting felony. In all these instances, the offender can still be held criminally liable, since he is motivated by criminal intent. Requisites. The felony was intentionally committed. The felony is the proximate cause of the wrong done. Doctrine of proximate cause. Such adequate and efficient cause as, in the natural order of events, and under the particular circumstances surrounding the case, which would necessarily produce the event. Requisites. The direct, natural, and logical cause produces the injury or damage unbroken by any sufficient intervening cause without which the result would not have occurred. Proximate cause is negated by active force, distinct act, or fact absolutely foreign from the felonious act of the accused, which serves as a sufficient intervening cause. Resulting injury or damage is due to the intentional act of the victim. Proximate cause does not require that the offender needs to actually touch the body of the offended party. It is enough that the offender generated in the mind of the offended party the belief that made him risk himself. Requisite for presumption blow was cause of the death, where there has been an injury inflicted sufficient to produce death followed by the demise of the person. The presumption arises that the injury was the cause of the death. Provided victim was in normal health, death ensued within a reasonable time, the one who caused the proximate cause is the one liable. The one who caused the immediate cause is also liable, but merely contributory or sometimes totally not liable. 2. By any person performing an act which would be an offense against persons or property, were it not for the inherent impossibility of its accomplishment or on account of the employment of inadequate or ineffectual means. Requisites. Impossible crime. Act would have been an offense against persons or property. Act is not an actual violation of another provision of the code or of a special penal law. There was criminal intent. Accomplishment was inherently impossible, or inadequate or ineffectual means were employed. Notes. Offender must believe that he can consummate the intended crime. A man stabbing another who he knew was already dead cannot be liable for an impossible crime. The law intends to punish the criminal intent. There is no attempted or frustrated impossible crime. Felonies against persons, parricide, murder, homicide, infanticide, physical injuries, etc. Felonies against property, robbery, theft, usurpation, swindling, etc. Inherent impossibility. A thought that B was just sleeping. B was already dead. A shot B. A is liable. If A knew that B is dead and he still shot him, then A is not liable. When we say inherent impossibility, this means that under any and all circumstances, the crime could not have materialized. If the crime could have materialized under a different set of facts, employing the same mean or the same act, it is not an impossible crime, it would be an attempted felony. Employment of inadequate means. A used poison to kill B. However, B survived because A used small quantities of poison, frustrated murder. Ineffectual means. A aimed his gun at B when he fired the gun. No bullet came out because the gun was empty. A is liable. Whenever you are confronted with a problem where the facts suggest that an impossible crime was committed, be careful about the question asked. If the question asked is an impossible crime committed? Then you judge that question on the basis of the facts. If really the facts constitute an impossible crime, then you suggest that an impossible crime is committed, then you state the reason for the inherent impossibility. If the question asked is he liable for an impossible crime? This is a catching question. Even though the facts constitute an impossible crime, if the act done by the offender constitutes some other crimes under the revised penal code, he will not be liable for an impossible crime. He will be prosecuted for the crime constituted so far by the act done by him. This idea of an impossible crime is a one of last resort, just to teach the offender a lesson because of his criminal perversity. If he could be taught of the same lesson by charging him with some other crime constituted by his act, then that will be the proper way. If you want to play safe, you state there that although an impossible crime is constituted, yet it is a principle of criminal law that he will only be penalized for an impossible crime if he cannot be punished under some other provision of the revised penal code. Art. 5. Whenever a court has knowledge of any act which it may deem proper to repress and which is not punishable by law, it shall render the proper decision and shall report to the Chief Executive, through the Department of Justice, the reasons which induce the court to believe that said act should be made subject of legislation. In the same way the court shall submit to the Chief Executive, through the Department of Justice, such statement as may be deemed proper, without suspending the execution of the sentence, when a strict enforcement of the provisions of this code would result in the imposition of a clearly excessive penalty, taking into consideration the degree of malice and the injury caused by the offense. When a person is charged in court, and the court finds that there is no law applicable, the court will acquit the accused and the judge will give his opinion that the said act should be punished. Paragraph 2 does not apply to crimes punishable by special law, including profiteering, and illegal possession of firearms or drugs. There can be no executive clemency for these crimes. Art. 6. Consummated felonies, as well as those which are frustrated and attempted, are punishable. A felony is consummated when all the elements necessary for its execution and accomplishment are present, and it is frustrated when the offender performs all the acts of execution which would produce the felony as a consequence but which, nevertheless, do not produce it by reason of causes independent of the will of the perpetrator. There is an attempt when the offender commences the commission of a felony directly by overt acts, and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Development of a crime. Internal acts, intent and plans. Usually not punishable. External acts. Preparatory acts. Acts tending toward the crime. Acts of execution. Acts directly connected the crime. Stages of commission of a crime. Attempt. Frustrated. Consummated. Overt acts of execution are started. Not all acts of execution are present due to reasons other than the spontaneous desistance of the perpetrator. All acts of execution are present. Crimes sought to be committed as not achieved due to intervening causes independent of the will of the perpetrator. All the acts of execution are present. The result sought as achieved. Stages of a crime does not apply in offenses punishable by special penal laws, unless the otherwise is provided for. Formal crimes, e.g., slander, adultery, etc. Impossible crimes. Crimes consummated by mere attempt. Examples: attempt to flee to an enemy country, treason, corruption of minors. Felonies by omission. Crimes committed by mere agreement. Desistance. Desistance on the part of the offender negates criminal liability in the attempted stage. Desistance is true only in the attempted stage of the felony. If under the definition of the felony, the act done is already in the frustrated stage, no amount of desistance will negate criminal liability. The spontaneous desistance of the offender negates only the attempted stage but not necessarily all criminal liability. Even though there was desistance on the part of the offender, if the desistance was made when acts done by him already resulted to a felony, that offender will still be criminally liable for the felony brought about his act. In deciding whether a felony is attempted or frustrated or consummated, there are three criteria involved. 1. The manner of committing the crime. 2. The elements of the crime, and 3. The nature of the crime itself. The attempted stage is said to be within the subjective phase of execution of a felony. On the subjective phase, it is that point in time when the offender begins the commission of an overt act until that point where he loses control of the commission of the crime already. If he has reached that point where he can no longer control the ensuing consequence, the crime has already passed the subjective phase and, therefore, it is no longer attempted. The moment the execution of the crime has already gone to that point where the felony should follow as a consequence, it is either already frustrated or consummated. If the felony does not follow as a consequence, it is already frustrated. If the felony follows as a consequence, it is consummated. Although the offender may not have done the act to bring about the felony as a consequence, if he could have continued committing those acts but he himself did not proceed because he believed that he had done enough to consummate the crime, Supreme Court said the subjective phase has passed. Notes on arson. The weight of the authority is that the crime of arson cannot be committed in the frustrated stage. The reason is because we can hardly determine whether the offender has performed all the acts of execution that would result in arson, as a consequence, unless a part of the premises has started to burn. On the other hand, the moment a particle or a molecule of the premises has blackened, in law, arson is consummated. This is because consummated arson does not require that the whole of the premises be burned. It is enough that any part of the premises, no matter how small, has begun to burn. Estafa versus theft. In estafa, the offender receives the property, he does not take it. But in receiving the property, the recipient may be committing theft, not estafa, if what was transferred to him was only the physical or material possession of the object. It can only be estafa if what was transferred to him is not only material or physical possession but juridical possession as well. When you are discussing estafa, do not talk about intent to gain. In the same manner that when you are discussing the crime of theft, do not talk of damage. Nature of the crime itself. In crimes involving the taking of human life, parricide, homicide, and murder, in the definition of the frustrated stage, it is indispensable that the victim be mortally wounded. Under the definition of the frustrated stage, to consider the offender as having performed all the acts of execution, the acts already done by him must produce or be capable of producing a felony as a consequence. The general rule is that there must be a fatal injury inflicted, because it is only then that death will follow. If the wound is not mortal, the crime is only attempted. The reason is that the wound inflicted is not capable of bringing about the desired felony of parricide, murder or homicide as a consequence. It cannot be said that the offender has performed all the acts of execution which would produce parricide, homicide or murder as a result. An exception to the general rule is the so-called subjective phase. The Supreme Court has decided cases which applied the subjective standard that when the offender himself believed that he had performed all the acts of execution, even though no mortal wound was inflicted, the act is already in the frustrated stage. The common notion is that when there is conspiracy involved, the participants are punished as principals. This notion is no longer absolute. In the case of People v. Niera, the Supreme Court ruled that even though there was conspiracy, if a co-conspirator merely cooperated in the commission of the crime with insignificant or minimal acts, such that even without his cooperation, the crime could be carried out as well, such co-conspirator should be punished as an accomplice only. Art. 7. Light felonies are punishable only when they have been consummated with the exception of those committed against persons or property. Examples of light felonies: slight physical injuries, theft, alteration of boundary marks, malicious mischief, and intriguing against honor. In commission of crimes against properties and persons, every stage of execution is punishable but only the principals and accomplices are liable for light felonies, accessories are not. Art. 8. Conspiracy and proposal to commit felony are punishable only in the cases in which the law specially provides a penalty therefor. A conspiracy exists when two or more persons come to an agreement concerning the commission of a felony and decide to commit it. There is proposal when the person who has decided to commit a felony proposes its execution to some other person or persons. Conspiracy is punishable in the following cases: treason, rebellion or insurrection, sedition, and monopolies and combinations in restraint of trade. Conspiracy to commit a crime is not to be confused with conspiracy as a means of committing a crime. In both cases there is an agreement, but mere conspiracy to commit a crime is not punished except in treason, rebellion, or sedition. Even then, if the treason is actually committed, the conspiracy will be considered as a means of committing it and the accused will all be charged for treason and not for conspiracy to commit treason. Conspiracy and proposal to commit a crime. Conspiracy. Proposal. Elements agreement among two or more persons to commit a crime. They decide to commit it. A person has decided to commit a crime. He proposes its commission to another. Crimes: conspiracy to commit sedition, conspiracy to commit rebellion, conspiracy to commit treason, proposal to commit treason, proposal to commit rebellion, mere conspiracy in combination, in restraint of trade, art. 186, and brigandage, art. 306. 2 ways for conspiracy to exist. 1. There is an agreement. 2. The participants acted in concert or simultaneously, which is indicative of a meeting of the minds towards a common criminal goal or criminal objective. When several offenders act in a synchronized, coordinated manner, the fact that their acts complemented each other is indicative of the meeting of the minds. There is an implied agreement. 2 kinds of conspiracy. 1. Conspiracy as a crime, and 2. Conspiracy as a manner of incurring criminal liability. When conspiracy itself is a crime, no overt act is necessary to bring about the criminal liability. The mere conspiracy is the crime itself. This is only true when the law expressly punishes the mere conspiracy. Otherwise, the conspiracy does not bring about the commission of the crime, because conspiracy is not an overt act but a mere preparatory act. Treason, rebellion, sedition, and coup d'état are the only crimes where the conspiracy and proposal to commit to them are punishable. When the conspiracy is only a basis of incurring criminal liability, there must be an overt act done before the co-conspirators become criminally liable. For as long as none of the conspirators has committed an overt act, there is no crime yet. But when one of them commits any overt act, all of them shall be held liable, unless a co-conspirator was absent from the scene of the crime or he showed up, but he tried to prevent the commission of the crime. As a general rule, if there has been a conspiracy to commit a crime in a particular place, anyone who did not appear shall be presumed to have desisted. The exception to this is if such person who did not appear was the mastermind. For as long as none of the conspirators has committed an overt act, there is no crime yet. But when one of them commits any overt act, all of them shall be held liable, unless a co-conspirator was absent from the scene of the crime or he showed up, but he tried to prevent the commission of the crime. As a general rule, if there has been a conspiracy to commit a crime in a particular place, anyone who did not appear shall be presumed to have desisted. The exception to this is if such person who did not appear was the mastermind. When the conspiracy itself is a crime, this cannot be inferred or deduced because there is no overt act. All that there is the agreement. On the other hand, if the co-conspirator or any of them would execute an overt act, the crime would no longer be the conspiracy but the overt act itself. Conspiracy as a crime must have a clear and convincing evidence of its existence. Every crime must be proved beyond reasonable doubt. It must be established by positive and conclusive evidence, not by conjectures or speculations. When the conspiracy is just a basis of incurring criminal liability, however, the same may be deduced or inferred from the acts of several offenders in carrying out the commission of the crime. The existence of a conspiracy may be reasonably inferred from the acts of the offenders when such acts disclose or show a common pursuit of the criminal objective. Mere knowledge, acquiescence to, or approval of the act, without cooperation or at least agreement to cooperate, is not enough to constitute a conspiracy. There must be an intentional participation in the crime with a view to further the common felonious objective. When several persons who do not know each other simultaneously attack the victim, the act of one is the act of all, regardless of the degree of injury inflicted by any one of them. All will be liable for the consequences. A conspiracy is possible even when participants are not known to each other. Do not think that participants are always known to each other. Conspiracy is a matter of substance which must be alleged in the information, otherwise, the court will not consider the same. Proposal is true only up to the point where the party to whom the proposal was made has not yet accepted the proposal. Once the proposal was accepted, a conspiracy arises. Proposal is unilateral. One party makes a proposition to the other. Conspiracy is bilateral. It requires 2 parties. Sedition. Proposal to commit sedition is not a crime. But if Union B accepts the proposal, there will be conspiracy to commit sedition, which is a crime under the revised Penal Code. Composite crimes. Composite crimes are crimes which, in substance, consist of more than one crime but in the eyes of the law, there is only one crime. For example, the crimes of robbery with homicide, robbery with rape, robbery with physical injuries. In case the crime committed is a composite crime, the conspirator will be liable for all the acts committed during the commission of the crime agreed upon. This is because, in the eyes of the law, all those acts done in pursuance of the crime agreed upon are acts which constitute a single crime. As a general rule, when there is conspiracy, the rule is that the act of one is the act of all. This principle applies only to the crime agreed upon. The exception is if any of the co-conspirator would commit a crime not agreed upon. This happens when the crime agreed upon and the crime committed by one of the co-conspirators are distinct crimes. Exception to the exception. In acts constituting a single indivisible offense, even though the co-conspirator performed different acts bringing about the composite crime, all will be liable for such crime. They can only evade responsibility for any other crime outside of that agreed upon if it is proved that the particular conspirator had tried to prevent the commission of such other act. Art. 9. Grave felonies are those to which the law attaches the capital punishment or penalties which in any of there are afflictive, in accordance with Article 25 of this Code. Less grave felonies are those which the law punishes with penalties which in their maximum period are correctional, in accordance with the above-mentioned article. Light felonies are those infractions of law for the commission of which a penalty of arresto mayor or a fine not exceeding 200 pesos, or both is provided. Capital punishment, death penalty. Penalties, imprisonment, grave, 6 years and 1 day to reclusion perpetua, life, less grave, 1 month and 1 day to 6 years, light, arresto menor, 1 day to 30 days. This question was asked in the bar examination. How do you classify felonies, or how are felonies classified? What the examiner had in mind was Articles 3, 6 and 9. Do not write the classification of felonies under Book 2 of the Revised Penal Code. That was not what the examiner had in mind because the question does not require the candidate to classify but also to define. Therefore, the examiner was after the classifications under Articles 3, 6 and 9. Felonies are classified as follows. 1. According to the manner of their commission. Under Article 3, they are classified as, intentional felonies are those committed with deliberate intent, and culpable felonies are those resulting from negligence, reckless imprudence, lack of foresight or lack of skill. 2. According to the stages of their execution. Under Article 6, felonies are classified as attempted felony when the offender commences the commission of a felony directly by overt acts, and does not perform all the acts of execution which should produce the felony by reason of some cause or accident other than his own spontaneous desistance. Frustrated felony when the offender commences the commission of a felony as a consequence but which would produce the felony as a consequence but which nevertheless do not produce the felony by reason of causes independent of the perpetrator. And, consummated felony when all the elements necessary for its execution are present. 3. According to their gravity. Under Article 9, felonies are classified as grave felonies or those to which attaches the capital punishment or penalties which in any of their periods are afflictive. Less grave felonies are those to which the law punishes with penalties which in their maximum period was correctional. And light felonies are those infractions of law for the commission of which the penalty is arresto menor. Why is it necessary to determine whether the crime is grave, less grave or light? To determine whether these felonies can be complexed or not, and to determine the prescription of the crime and the prescription of the penalty. In other words, these are felonies classified according to their gravity, stages and the penalty attached to them. Take note that when the Revised Penal Code speaks of grave and less grave felonies, the definition makes a reference specifically to Article 25 of the Revised Penal Code. Do not omit the phrase, in accordance with Article 25 inches because there is also a classification of penalties under Article 26 that was not applied. If the penalty is fine and exactly P200.00, it is only considered a light felony under Article 9. If the fine is imposed as an alternative penalty or as a single penalty, the fine of P200.00 is considered a correctional penalty under Article 26. If the penalty is exactly P200.00, apply Article 26. It is considered as correctional penalty and it prescribes in 10 years. If the offender is apprehended at any time within 10 years, he can be made to suffer the fine. This classification of felony according to gravity is important with respect to the question of prescription of crimes. In the case of light felonies, crimes prescribe in 2 months. If the crime is correctional, it prescribes in 10 years, except arresto mayor, which prescribes in 5 years. Art. 10. Offenses which are or in the future may be punishable under special laws are not subject to the provisions of this code. This code shall be supplementary to such laws, unless the latter should specially provide the contrary. In Article 10, there is a reservation. Provision of the revised penal code may be applied suppletorily to special laws. You will only apply the provisions of the revised penal code as a supplement to the special law, or simply correlate the violated special law, if needed to avoid an injustice. If no justice would result, do not give suppletorily application of the revised penal code to that of special law.